Hey, David.
Hey, how you doing, Trent?
Doing well. Welcome, everybody. We're going to be doing the podcast a little differently today. Today, we're going to be doing it over Zoom. Sadly, David's a little far away from me, but we still have a lot of very interesting things to talk about. So, David, go ahead and explain to us kind of a little bit about why a claim has to go into litigation. What are the main reasons?
Okay, well, normally, the process is when we receive a claim and we file it on the client's behalf, we do it informally, usually through a letter. We send them all the documentation and information available. And if the claim doesn't get settled at that particular point in time, there's usually one of two reasons. One is that the claim is just denied outright, that the insurance carrier is basically saying we deny liability in this case, or whatever matter. Or the second is they accept liability, but the amount that they're willing to pay to compensate the client is just way too low given the client's injuries and nature of it. And it's normally the second one that we normally have to go ahead and file a complaint. That's the only way to get the insurance company to move in this matter and to persuade them that their offers are inadequate. And so we start a lawsuit process, and we move that along, and it usually results in us getting a higher compensation for the client. Now, the initial process in filing a lawsuit is filed in the county in which the accident or incident took place. Usually also where the plaintiff resides, sometimes where the defendant resides. There's the only issue with litigation is costs are involved in litigation. There is a cost to filing a lawsuit. And in South Carolina, it's about $186 to file a lawsuit in Court of Common Pleas. And once that's done, the insurance carrier hires their own attorney counsel to defend the case. And that's when we start working with the attorney directly rather than working with the adjuster. And we usually have a better opportunity at that point in time to discuss all the issues in the case, provide any additional information. It's also through the litigation process that they're going to want to take the client's deposition, an oral statement under oath. They may ask for additional medical records and everything to verify the damages in the case, if this is an injury case. And that process just takes a while. Normally, if we have to go into litigation and file a complaint, you can expect that it's going to take between 6 months to a year additionally to get that claim resolved. Mostly claims are resolved still through settlement. Some claims do have to go all the way to trial, and that depends on the issues in the case, but we still can't come to an agreement on either liability in the case or the damage that their compensation that they're offering is still way too low. And then we'll have to go to trial and a jury decide. Our job in all of this is to represent the client vigorously and pursuing every avenue we have through the litigation process, doing discovery that we feel is necessary to further the claim. Sometimes that includes taking depositions of treating healthcare providers to give additional information as to the client's injuries. Sometimes we have to do an evaluation in terms of how the injuries may have affected the client's quality of life, which are additional damages that need to be considered. So there's a whole realm of things that we can get into during the course of the litigation to kind of booster the client's claim and hopefully get them the compensation they deserve.
Well, that's definitely a lot. And I know that for people who are very new to this, you discussed not only the main reasons, but also the process. But I think what can be a little scary is just hearing lawsuit in general. And so what are some of the obligations that the client is going to have on that side? Because it's not just a hands-off process at this point.
Definitely. The client has to be fully involved as well. And we do all the major work, but we need the involvement of the client, especially when it comes to the discovery process. One of our paralegals in the office will contact the client and go through some detailed questions that need to be answered. A lot of it involves past medical history. It might involve employment history. It might involve other things that are issues in the case. The client has to be readily available to assist us in getting that information from the client. And obviously, if an oral deposition is going to be taken, the client has to submit to that deposition. And if the case goes to trial, you may have to submit to, taking a few days or a week of your life while the case is being decided in court. So it's a joint effort. Obviously, we work closely with the clients, and our paralegals work closely with the clients to put together the best argument we can to further the claim. But we all have an obligation to do something here.
Definitely. If you had to put a percentage on it, how important would you say the client's cooperation with your process is? Because sometimes the client might not agree, and it's obviously your job to be the facilitator and help them make the best decision. Ultimately, it's up to them.
Okay, it's definitely the client definitely has to be committed to and place their faith and trust in us. Be committed to taking our advice, because we've been doing this for a long time. But they also have to commit some time and effort into the matter. Most of this, every case that goes through litigation, eventually we go to what's called a mediation conference. And that's where all the parties get together with a neutral party, a mediator, to see if the issues can be resolved. The client has to be fully involved in that process. Now, even though we fully represent the client and do everything we can, it's the client who we ultimately work for. And it's the client who ultimately decides whether a case is going to get settled or not. It is our job to make sure that we give the client as much information and advice as possible, to make sure the client makes an informed decision when it comes down to that. But it is more involved from a client's perspective when a case goes into litigation than it would be if the case didn't go into litigation. There's a lot more activity that the client has to be involved with.
A lot of times when there's a settlement offer, whether or not it's enough to justify a settlement, the question comes into how long am I willing to go through the litigation process to hopefully reach the settlement that you want. Talk about, how long does it typically take to resolve a litigation?
It somewhat depends on the nature of the claim itself and how many issues are involved. Sometimes how many defendants are involved. Sometimes we have cases where there's more than one defendant, and that complicates the case. So somewhat depends on the parties, but typically a case, and this is, I'm thinking post-COVID-19 now, because everything was fully delayed in the last year, and we couldn't give you any time frame. But assuming we get back to a normal time frame here, 6 months to a year, it's going to take at least to get to the mediation stage, and maybe a little over a year if the case has to go to trial. What happens if the case goes to trial? You're competing with a lot of other cases, and there's only so many judges, so many weeks that they actually even hold trial. So you're somewhat caught into that. So, and I understand that, and I think the most frustrating part on clients is how long litigation takes. So I try to keep the clients informed totally along the process, to let them know, well, basically, if you haven't heard from me, it means nothing's going on. But as things progress, to keep them fully informed as to where we are in the process. Always keep my phone available. They can call me at any time to see where the case is and give them an update, because it is a frustrating experience. And that's what I find. And I've been doing this for 30 years. Most clients are frustrated by the length of time litigation takes, and a little bit about some of the obligations that are involved in their participation in the litigation. And it can be frustrating at times, but I hope to guide them through that. But I would say if we have to file a lawsuit, and sometimes, to be honest, sometimes once we file a lawsuit, that may be in and of itself enough to move the insurance carrier. And I have settled cases shortly after filing a lawsuit, because that's what took them, to let them know that we're serious about representing our client and that we're willing to take this all the way to trial if necessary. And sometimes that gets them to rethink things. But normally, I think you have to at least expect 6 months to a year to get it resolved once we file a lawsuit.
And you kind of touched a little bit on mediation. Could you give me a little bit more information on how important that is to the process of litigation?
Okay, so it's so important that it's court-ordered mediation, actually. The court requires mediation. They've been doing this for quite a number of years now. So it's not the court requires the parties to hire a third-party neutral, as we call them, a mediator, to listen to both sides of the case and see if they can facilitate a settlement. This usually happens further down in the process. Normally, after discovery is completed, at least 6 months into the process before you actually have mediation. Sometimes we can have an early mediation, but it's where all the parties get together. Mediator listens to both sides and see if he can get the parties to agree. I have found that mediation can be at least 95% effective in settling cases. Some cases are a little different. For instance, I can tell you a medical malpractice case, because of the complexities involved in that, there's a 95% chance those cases will actually go to trial. Whereas non-medical malpractice cases, there's a 95% chance that they will not go to trial, because there's not as many complex issues. And to be honest, you're not dealing with healthcare providers who make it more difficult sometimes to settle cases. But mediation can be extremely helpful. It's a compromise of sorts, but the best thing about mediation is the client has control of the process in that regard, and that they can decide if they're going to take a settlement or not, and it's in their hands. If you go to trial, the worst thing about going to trial is you put your decision-making process in the hand of 12 strangers. And I've been doing this again for a long time. Juries are a necessary part of the way we adjudicate claims, but it's very difficult to get 12 people to agree on any one thing. So it really is more of a gamble going to trial than it would be. So the incentive is to try to get it settled before going to trial. But sometimes we can't do that, and it's necessary, we'll go to trial. But if we can mediate a settlement or settle the case along the way, it's mostly in the client's best interest.
Definitely, the risk goes up when you go to trial, as well as the costs involved.
Yeah, there's and it's more costly to go to trial. You have to have more people come to trial to testify. We have to take depositions of all the treating healthcare providers that are involved in the case. So it's an expensive process as well. But every case we have to look upon individually in the terms of the issues in the case, in terms of the damages in the case. And then we make decisions based on that. There's no generalization that I can give for all cases. Like I said, medical malpractice cases are their own creature, so to speak, and they have their own idiosyncrasies. And every other case is individual. It's individual to the client, and we understand that. And I understand my client's individual needs, and I try to structure the way I proceed in any case according to what their needs are.
So you definitely covered why you'd have to go to trial if there was difficulties with discovery or just a complex process, experts, witnesses. So what kind of other reasons might you have to go to trial if the mediation fails?
Well, definitely if liability is an issue and you can't resolve the liability issue, the defendant just basically saying, I didn't do anything wrong. And we say, well, the facts show differently that you did. I mean, those are the cases that tend to go to trial more often. You just can't, you got to put it in the hands of those 12 people to decide, let them listen to all the facts and use their common knowledge to decide which story is the more persuasive story, or which story makes the most sense as to who was really at fault in the case. I mean, so that's the major reason to go to trial. The secondary reason is when it comes strictly to damages. Usually those, for the most part, I think you can work out prior to trial, unless there is such a wide gap between the issue of how much money the carrier is willing to pay and the client is willing to accept. But the major reason you're going to trial is because the liability is a big issue.
Definitely. Just really quick, what are some of the reasons why you feel like a jury is really hard to persuade?
Well, I'm not saying it's hard to persuade. It's hard to get 12. You get 12 individuals. We're all individuals. And one thing I try to, when we're going to trial, I explain to clients, well, especially if you come from a large family, you're all related to each other, and sit around the Thanksgiving table, and there's 12 of you. All 12 of you are going to agree on every topic that comes up at that table. And 99.9% of the people will say no. So even with people we know, that we love, that we've been around a long time, we share a common bond, we were not going to agree on everything. So now you put 12 strangers together. And then the dynamics in that case is, to be honest, there's some people on the jury that don't want to be there. They got called to jury duty and they wish they weren't there at all. There are some people who have a little stronger attitude than others, shall we say. And so they tend to be more persuasive in that jury room. But the problem is I can be as persuasive as I can, and I always feel like I do a great job at trial. But once I'm done and those 12 people walk into that room, I'm not in that room with them anymore. And it's those 12 people just talking among themselves and what they decide. And there's a lot of factors that go in. After trials, I usually get the opportunity to talk to a few jurors to try to understand what the process that went in there. And you'll find that it runs the gamut. There's people who take it very seriously. There's people who are just in a hurry to get the thing over with and let's just get a verdict and get out of here. And there's people who are intimidated by other jurors. I mean, it runs the gamut. So there's risk. I mean, it's a great system, and I wouldn't do anything to change the system. I don't think you can. But there's risks involved in doing it. That's all I can say.
Well, thank you so much, David. I definitely learned a little bit from talking with you today, and I hope our audience did as well. Definitely check out our weekly podcast. It'll be coming up on Wednesday. So thank you again for tuning in, and thank you, David, for taking the time to talk to us about litigation.
Okay, thank you.